Ladies and gentlemen, as businesses seek opportunities abroad, confidence in dispute resolution mechanisms is key to enabling the flow of cross-border trade and investment. Moderating the next panel is Mr. ONERHT Campos, partner at RHT Law Asia. He will be joined by Professor Leslie Chew, Senior Counsel and Senior Consultant at RHT Law Asia and Dean of the Singapore University of Social Science School of Law. Professor Darius Chan, Associate Professor of Law at Singapore Management University and Deputy Director of Singapore International Dispute Resolution Academy. And Mr. Vivek Kathpalia, Managing Director and Chief Executive Officer of Cyril Amachan Mangalda, Singapore. This next panel will examine the challenges in settling disputes across China and ASEAN, as well as explore traditional and alternative dispute resolution mechanisms.
Good afternoon and welcome to our second panel discussion on updates and challenges in settling disputes across China and ASEAN. Let me start off the session today by first setting out the context and parameters for our discussion. Assume that you conduct business across one or more countries in the region and you enter into numerous cross-border agreements for investment, goods and services. In the course of doing so, you are likely to encounter numerous challenges, some of which evolve into disputes with your counterparties. Your counterparty hail from an ASEAN country or China, or from outside of ASEAN or China, and have different political, socio-economic, and cultural backgrounds, which may impact the way business is done and how disputes may be resolved. How do you navigate these political, socio-economic, and cultural differences? What is the framework or approach by which you want to resolve your disputes? Oftentimes, you may find yourself in a disadvantageous position if you did not carefully consider these differences and your options at the time of making the investment or entering into an agreement. The international or cross-border dimension of the question also requires that you consider several important factors when selecting a forum or mode for a dispute resolution. These factors include: is the forum neutral? Is a settlement agreement, award, or judgment obtained in that forum enforceable in another jurisdiction where recovery can be obtained? Does the forum have a robust legal system and a healthy ecosystem of domestic and international arbitral institutions, arbitrators, lawyers, and mediators? And does the forum have good infrastructure and connectivity? Ultimately, a forum of choice should enable you to obtain an efficient, just, and fair resolution of the disputes. The 2021 Queen Mary University of London and White & Case International Arbitration Survey ranked London, Singapore, Hong Kong, Paris, and Geneva as the 5 most preferred seats for arbitration, with Singapore and London sharing joint first place. To help me discuss these issues, I'm pleased to introduce to you our distinguished panel of speakers. Let me start from the furthest from me. First, Mr. Vivek Kafpalia. He's the Managing Director and CEO of Cyril Amachan Mangaldas, Singapore. Vivek Kafpalia has over 22 years of legal experience, 14 of which have been in Singapore as a licensed foreign lawyer since 2007. He has vast experience in advising varied international clientele in Singapore, Japan, USA, and globally with respect to their Indian law requirements. He has been involved in marquee transactions and has assisted leading companies enter the Indian market. Vivek has a wide range of experience in various practice areas, including mergers and acquisitions, private equity and venture capital, transactions, technology, telecommunications, and education. In his early days, he started in the area of arbitration disputes and is a solicitor at the Bombay High Court. So welcome, Vivek.
Thank you.
Next, I have Professor Leslie Chew, Senior Counsel, who is a Senior Consultant at RHT Law Asia. With a prolific career spanning 42 years of legal experience, he has spent 7 years in the judiciary as a senior district judge and has the distinction of being appointed senior counsel by the Supreme Court in 2000. Professor Chew's main areas is at the commercial bar, and he has occasionally represented clients in commercial crime and white-collar cases. He has also acted as senior counsel for major banks in Singapore and a number of private banks, as well as acting in medical cases on behalf of restructured hospitals and private hospitals. Welcome, Leslie.
Thank you.
Last but not least, Darius Chan is Associate Professor of Law Practice at Singapore Management University Yong Pang Hau School of Law. He is concurrently appointed Deputy Director of the Singapore International Dispute Resolution Academy and Director of the SMU Law Academy. After a decade in private practice, he now practices as an independent arbitrator and advocate with Breakpoint LLC and Fountain Court Chambers. Darius is qualified in New York, England and Wales, and Singapore after serving a stint as a Justice's Law Clerk and Assistant Registrar of the Supreme Court of Singapore. Welcome, Darius.
Thank you, Conrad.
I believe we also have our ASEAN Plus legal network lawyers who are joining us today. Mr. Pichan Suparangsi of the Bangkok Global Law Officers Limited. Pichan, if you are there. And Mr. Carl Hines of Holding Redlich of Australia. Let me start off by perhaps asking a question of starting with Vivek. So Vivek, when drafting agreements in a cross-border transaction situation, how do you address the question of dispute resolution with your clients?
I think if you look at it more from a cross-border perspective and India, ASEAN or India-China perspective, India has some unique reservations, for example, when it entered into the New York Convention. And so whilst India as a member of the New York Convention is still reserves the right to notify countries that it will recognize as those providing reciprocal terms.
Right.
And therefore, when drafting dispute resolution contracts, especially in a cross-border scenario, one has to identify the countries involved, so India and which other countries. So for example, if you look at ASEAN and even the broader Asian region, from an arbitration perspective, Singapore, Malaysia, Thailand, Philippines, and if you go further north, then obviously Japan, Hong Kong, are all notified separately by India. So any of these jurisdictions could practically be the seat of arbitration if you want to have a foreign seat or a neutral seat. Mm-hmm. So that's one very important context one takes into consideration. Again, obviously you have to look at it from the perspective of who you're representing, which side, but assuming that you want a neutral seat.
Right.
And therefore, most of the contracts that I have looked at over the past many years, especially in my corporate and M&A practice, we have seen that Singapore and London are more, I would say, common as far as an Indian dispute resolution scenario is concerned. Familiarity, common law, and enforcement statistics of arbitral awards either enforced in India or elsewhere. So what used to be, I would say, at least in India a decade ago, called the midnight clause, where no one really paid attention to the dispute resolution clause. It was somewhere with miscellaneous. Right. And you would just, at the last minute say, okay, not Singapore, let's do it here. You would not call it seat, you would call it venue, and then you would spend hours in court. I think we have evolved. So I think these are some of the important considerations from my perspective. Governing law obviously is another important consideration.
Yes.
There have been number of judicial pronouncements in India from the Supreme Court, which has basically, in a nutshell, made India fairly arbitration-friendly, non-interventionist as far as the courts are concerned, and respecting party autonomy. So then it really boils down to the commercial arrangement and the enforceability aspect when we look at these clauses.
And has the Indian courts enforced arbitral awards coming from the various venues in the region, including Singapore or Hong Kong?
Yes. If you look at over the years, if you take Singapore, for example, I think the largest contributor to cases at the SIEC is from India, followed by China, the last statistics. And therefore, Indian parties are fairly comfortable choosing Singapore as a seat. And one of the reasons, obviously, is that most of these awards are getting enforced effectively in India. And the courts are now pretty hands-off. And the Arbitration Act in India, the part of the law which deals with foreign awards and judicial pronouncements supporting those sections have also improved drastically, where the courts now have very limited scope to interfere, very, very limited. So it's been narrowly defined what you can touch and what you can't touch, which wasn't there earlier.
Okay.
So therefore, it's by far much more efficient today.
I'll come back to you on some of the points that you've made,
Sure.
and then but I'll just take in the input from the other speakers now. Professor Leslie, you've been practicing many years, and nowadays you do a lot of arbitration as an arbitrator. How do these factors of choice of law and jurisdiction impact an arbitration proceeding?
Yeah, thank you for that question. Yes, I'll take the point starting with some of the comments made by Vivek. I think even from the point of view of an arbitrator, excuse me, the same principles apply. As an arbitrator, you want to do your best to give the parties a solution that's workable and enforceable, of course. The end product of an arbitration should be an enforceable award. And to that extent, it depends quite a lot on the parties from the very beginning. And as Vivek has pointed out, it's about getting the right forum, and the right forum leads into issues as to where you're going to enforce. Because if you take an award from Singapore, then automatically when you try to enforce across borders, it is identified as a Singapore award. So there are dynamics involved as to recognition and so on, even within the framework of the New York Convention. So that's one, and I like the fact of reference made by Vivek to the midnight clause. Things have evolved, but of course we all know parties, when things are hunky-dory, shall we say, don't think very much about disputes, and I think as lawyers we all come across that. And it's not wrong. When you enter into a deal, do you look into bad things? You look at good things, right? But of course, as lawyers, we have the duty and obligation to advise our clients that you do need to think about the downsides. And in terms of dispute resolution across borders in this region or elsewhere, really the dynamic of choosing the right forum, I think, is critical. Without going into the technical details, as lawyers, we know that you have the seat, and you also have the governing law of the transaction. So there are a number of, shall we say, moving parts at play. And I think parties need to think through. And I guess the best advice that I can offer is take advice from the lawyers and pay attention to the advice. Quite often, our clients look at it purely from a commercial point of view. Yes, that's not wrong, of course. That's the raison d'etre of what they're trying to do. But remember that when you cross borders, it gets a little bit more complex than possibly than in your local jurisdiction, for example. And in Singapore, of course, it's so small, nobody's more than one phone call away. But if you're transacting business from Singapore with another party, let's say out of Boston, Massachusetts, there are a lot of things that you have to think about, because one is distance, and distance does translate into certain complexities.
Right.
So that's how I look at it.
Right. Darius, how would you advise clients on a cross-border transaction with regard to dispute resolution?
Thanks, Conrad. In my experience, it's always going to be a negotiation and a give and take between the two commercial parties. One commercial party, in my experience, when I advise clients on this, will want a particular governing law, right? They would want Indian law or they would want English law. And in order to barter trade, the other party will say, fine, we will give you Indian law or English law, but in return, we'll settle any disputes in Singapore or in Hong Kong. And that's how typically, in my experience, a compromise has been struck.
I have an experience where we are involved acting for a Danish law firm, which advises a consortium made up of the Taiwanese party and with European funders, and of course European technical expertise regard to building wind farms in Taiwan. And guess what? The governing law and the seat of arbitration is SIC, and governing law is Singapore, although subject to applicable Taiwanese law for whatever is domicile. So that's how far we've gone in making that kind of choice and making that bargaining position of what would be something that's neutral, which both parties can accept.
I'd just like to add one more point, that sometimes we tend to make some of these clauses fairly complex, and that has always, I think, led to trouble. Right. So, but the other advice I give clients is try and, after, as Darius said, you negotiate the governing law, you negotiate the seat. Try and keep the clause as simple as possible. If you can simply refer to a set of rules of the arbitral institution without trying to draft it out yourself, it's going to save you a lot of time at a very pre-dispute stage, when you could have simply gone straight into the arbitration. So simplicity also, I think, is very important in a dispute resolution clause.
Yes. So now I'm going on to the next, another question, all right? And so when one of the parties is a Chinese entity, how does Singapore and Hong Kong weigh up or compare as a forum for dispute resolution? And are there alternatives? For this question, I'll start off with Darius this time.
Yes. I think we all can appreciate that Singapore and Hong Kong have been the two most popular places to resolve disputes, at least in this part of the world. Singapore, as Vivek was saying just now, at the SIAC, India and China, they're the top two users of SIAC arbitration. And we've got cases coming up from the Singapore courts involving Chinese parties as well. So I can say that Singapore is a relatively popular place for Chinese-related disputes, right? China-related disputes. On the other hand, in my view, I think Hong Kong has a slight edge because it is the only jurisdiction in the world. For now, it is the only jurisdiction in the world that has the advantage of having certain arrangements with mainland China that all other jurisdictions do not have. So let me make this good. In particular, there are three kinds of arrangements that I have in mind that Hong Kong has with mainland China. The first would be arrangements concerning reciprocal enforcement and recognition of judgments. Right? So if you've got a judgment from the Hong Kong courts or the mainland Chinese courts, we can easily enforce those judgments between Hong Kong and China. The second kind of arrangement will be arrangements concerning mutual assistance in interim relief. Right? That's been particularly important. So if you are involved in a Hong Kong arbitration, you can get assistance from the Chinese courts to get a freezing order on assets on the Chinese party in mainland China. That's been extremely powerful, and I want to emphasize that. The third arrangement is that after the award is rendered by the tribunal, There are arrangements, again, mutual recognition arrangements that allow for the Chinese courts to grant relief to help the enforcement of the award. And again, that's a very powerful tool to ensure that the award that you get at the end of the arbitration process is worth something. So practically speaking, just summing up, practically speaking, in my experience, when it involves a Chinese outbound investor, right? Someone coming out of China, they are very happy to choose Singapore.
Yeah, going in.
Whereas when it's going in to China, that's when parties will want to use Hong Kong because of the availability of these arrangements that I spoke about.
So based on what Darius has just said, let's take an Indian party.
Yes.
That's trying to invest into China.
Yes.
Singapore, Hong Kong, or someplace else.
No, I agree with Darius. If I'm representing an Indian party that's investing into China, and I now need to choose a jurisdiction for arbitration, I will really look at Hong Kong based on what these reciprocal arrangements that Hong Kong now has. Because at the end of the day, I want to be able to enforce effectively and not stumble in a non-reciprocating kind of situation. So in fact, HKIC, I was speaking to them. This is the Hong Kong International Arbitration Center, and this is one point that they told me that for India-China arrangements, Hong Kong actually is now very well placed. So we will certainly look at that for our Indian clients.
Yeah.
Okay.
If I could weigh in, I think,
Yes.
of course, I also agree. And I think it's worth reiterating what Darius pointed out about, for example, the interim measures, the freezing order. It's a very powerful tool. And in business, quite often you have to fall back on something like that in the course of proceedings. And when it comes to enforcing in China, obviously Hong Kong, with the reciprocal arrangements that Darius referred to, are not only easy but possible, whereas it may not be possible even for Singapore. In fact, we know for some of the interim measures, Singapore will not be able to effectively do it. So I think that's a very key thing for business people to understand, because at the end of the day, it's not the dispute process has to have an end product which is usable by the parties, and really that's what it is. And enforcement is the key. I used to joke with people, it's not your clients are not going to frame the award or the judgment. Right? It's got to be monetized eventually, because business is in the business of making money and getting back their return on investment.
Yeah.
Right. So one of the main, very important factors to consider is the ability to enforce that award that you get after your arbitration.
Absolutely.
And in the process, also get the necessary assistance to aid that process.
Yes.
Professor Leslie, you've sat as arbitrator. Now, let's assume that one of the parties is a Chinese entity and another hails from Malaysia with a common law tradition. So Chinese is civil law generally. How do you deal with these cultural differences and their expectations of how an arbitration is to be conducted?
Yeah. Okay, I think there are 2 points I would like to make. One is starting on a positive side. When I first started, which years ago, I think, say in the 90s, there was this very stark difference between the civil law approach to dispute resolution and common law. But in my view and in my experience, I think there's quite a lot of convergence coming. That's because of, whether we like it or not, globalization of trade. Eventually, people get used to things. So I'll give you a small anecdote. Way back, you're talking about maybe 80s, some of the Japanese parties who got involved in disputes in this part of the world, they of course come from the civil law tradition, found cross-examination by common law lawyers quite offensive. Okay, so of course,
robust.
We say robust, they say offensive. So, for example, they would not tolerate. I remember one case, they found it very insulting when a lawyer suggested that the chairman of the company was lying. Right? Now, of course, there's better and delicate ways to say it, but nevertheless, they found it insulting. But today, of course, things have changed. One of the things I think we should recognize as practitioners in international cross-border work in terms of the law is how much various arbitral institutions have contributed around the world through the rules that you mentioned, and also the International Bar Association. As many lawyers and commercial parties may be familiar. Some of the mechanisms introduced in arbitration, like taking of evidence, that works out a compromise between the civil law and the common law system, emanates from the efforts of lawyers within the IBA. I'm thinking, of course, of the IBA rules for taking evidence. And these are good efforts, including UNCITRAL's efforts through the arbitration framework. So I think these are important things that has helped us. Going back to your question, fundamentally, I think from my view as an arbitrator, while you recognize the differences, you try to work out the similarities. Because after all, you're trying to resolve a dispute. You don't want to be the person to contribute to more disputes. So one concrete example I'd like to offer and put out there for commercial parties is what Vivek mentioned about rules. Quite often parties forget about the rules, right? And they have a nice arbitration clause with no reference to rules. So in teaching arbitration, people ask me, so what do you do? I say, here's where you have to be a negotiator with the parties and tell them, look, some rules are better than no rules. Do you really want me as an arbitrator to make up rules as I go along? You know, some of them will say, you know, well, we heard that arbitrators are master of their own rules. So yeah, very good, but are you going to do it step by step? It's not helpful. Actually, I have a concrete example. Recently, a Korean party and a Singapore party had an arbitration in Singapore, but they had not chosen any rules. And in fact, there was a double whammy there. They did not even decide on the governing law of the contract. So we had to work that out. So in reference to what I said about international bodies and agencies helping out this process, in that case, I suggested to the parties, and they actually adopted the UNIDRA rules for contracts. So I say, look, it is a United Nations attempt to compromise between civil and common law. At least we understand, you understand the principles. Why don't we look at that rather than nothing? You know? Same for the rules. So I think that's what my take will be in terms of the two competing systems. The last point I'll make with reference to the context of your question is for the cultural differences. I think that should not be underestimated. But again, I think it shouldn't be overblown. I used to joke that, you know, eons ago, even in this region, businessmen knew how to trade cross-border without sophisticated legal instruments. It's really people, right? If you want to do a deal, you will do the deal. And I think that should not be lost on us as professionals. But at the same time, we should recognize cultural differences. Even in ASEAN, I'll end with an example. I used to act for quite a substantial Indonesian client, and he used to say, you know, I've been in Singapore a long time, but I find you people very rude. So I said, but how can you say that? He said, well, when you want to do work with me, you start talking about the agenda, you talk about time frames, but you never once ask me how my grandchildren are, how my health is. Drink a cup of coffee with me first, you know. So I think there's a lesson to be learned. Culturally, those of us in Singapore and perhaps jurisdictions were a little bit more westernized. I know it's not a nice thing to say, but I don't mean in a derogatory sense. We are schooled in efficiency more than looking at people as people. And I think in this part of the world, I think it's quite critical. Because sometimes we forget this region has a very long and rich history culturally. So we need to be a bit more sensitive to these things. Of course, we cannot depart from the mechanics of what we're doing, but I think bearing that in mind will help, shall I say, smooth the process a little bit more, rather than making it, after all, we're facing confrontation, right? So we need to bring the temperature down rather than up. That's how I look at it as an arbitrator.
So I'm glad you raised the point of rules, because sometimes the rules or the manner of conduct of the arbitration is very important.
Yeah.
Sometimes it's better to agree and discuss what the rules are, even at the time of entering the agreement, even before the conflict arises. So do you have any comments with regard to institutional arbitration with its rules and an ad hoc kind of arbitration which is not governed by rules? Can you comment on that?
Sure. In my experience, most of the contracts that have come across my desk have increasingly chosen institutional arbitration. Yes, they are more expensive, But in my experience, commercial clients have now realized that there is a value to institutional arbitration. With an institution helping to move the process along. There's someone to pick up the phone to, right? Resolving disputes involves humans, right? It's not just a robot there. And I'm increasingly seeing ad hoc arbitration fall by the wayside.
Yeah. Right.
Whether that's a good or a bad trend that perhaps can be discussed for another day, but anecdotally, it's been almost overwhelmingly institutional arbitration on my desk.
Yeah. In fact, I agree with you. In India, we only had ad hoc arbitration for a number of years.
Right.
And effectively, and again, I'm not, it played its role. Effectively, you were in a court with a judge without being in the court with the judge. And with no disrespect to anyone, but that system didn't function the way it should have. Whether it actually ended up being more expensive, at least from my perspective, in an India scenario, right? And so therefore, institutional arbitration, whether they were foreign institutions or even institutions in India, we have now 1 or 2 good institutions in India, which are fairly good for domestic arbitration. People have realized that, look, it's more efficient, it's faster, there is someone that's controlling the process. Versus getting an adjournment for 6 months because someone felt that was appropriate. So I think that the movement from ad hoc to institution arbitration is very positive. India still has a large number of ad hoc arbitrations, mostly the domestic arbitrations, but most of our cross-border arbitrations are veering towards institutional arbitration.
Right.
Yes.
So now we are been talking about arbitration. And as a mode of dispute resolution. And obviously there are different modes of dispute resolution. But since we're on the topic of arbitration, let me just carry on with arbitration first before we move to the different modes. So we've been talking about all the positive factors of arbitration, and one of the main ones being the reciprocal enforcement of arbitral awards because of the New York Convention, which, well, all the ASEAN countries in China, and in fact, more than 150 countries have all signed up to this convention and ratified it. But are there drawbacks? And one of the drawbacks I'm thinking about is costs and what they call due process paranoia. Recently, Mr. V.K. Raja, in an article regarding the ICC, his experience with the ICC rules, and that's ICC is another institution.
Yes.
Debating the issue of whether or not there is due process paranoia in arbitration. Let me explain what due process paranoia is. Because an arbitrator is not a court, it sits at the behest and consent of both parties. Yeah. And his arbitral awards, in an award that he gives, can eventually be challenged by one of the parties. If that party felt that he was not given a due process, he was not given a right of putting in submissions, he was, and many then use that as a tactical to either delay or disrupt the proceedings. So, for example, at the hearing, then suddenly submitting new evidence, new opinions, and wanting to call an expert, and then delaying the whole process. And the arbitrator finds himself in a quandary as to whether or not to say, yeah, I'll receive this evidence, or if he does not, will it be challenged when he issues his award? Now, but what is your experience, and is it really true that there is due process paranoia?
That is.
Any one of you want to take this question?
Okay, I'll take a step at that.
Okay.
I've taught arbitrators, people who want to qualify as arbitrators or become arbitrators under the auspices of the Singapore Institute of Arbitrators, as well as the GCI, the Graduate Certificate at NUS Law. This is what I share with the participants and the students. I think if you just take a step back and look at the success of arbitration, international arbitration in particular, while we say that, you know, the question you posed raised some interesting issues, but if we take a step back and look at it, the success of international arbitration is quite remarkable from this perspective. There is no supra-agency to actually supervise it. There's no court actually administering it in the sense that lawyers understand of, domestic jurisdictional courts, national courts, and yet it works. So I think there are two parts. The way that I will answer your point, the question you raised, is in two parts. One, the first part is, it very much depends on how strong the international arbitral community remains. And in that way, when I share with people getting into arbitration, I tell them to remember that if you want to be involved in arbitration as an arbitrator, you have a responsibility to ensure that the integrity of the process, because there's nobody looking over your shoulder. So it is your job, and really you must take it seriously. Otherwise, the system will fail, and that's of course a disaster, right? The second thing is, I think today, if we hark back to the point about the rules, there's enough rules and sufficient national rules in terms of enabling legislation, which allows due process to be safeguarded. Now, I think people will argue on a selective basis and say that one failed and this one failed. If you take a broad view overall, and harking back to my first point, it's remarkable that it has worked, and it's because I would argue that all of the participants, not just the arbitrators, but parties involved in international arbitration, have been very conscious about doing it the right way and the proper way. And the question that you alluded to about the due process, I think everybody, in my experience, the ones that I've been involved, people work very hard to ensure there is due process. Counsel do their job. Arbitrators forget about things, and the counsel will remind them, say, oh, we haven't dealt with this. This is critical. And every party involved in the dispute process, whether counsel or even the parties themselves and the arbitrator, must be reminded that at the end of it, we're talking about something that's enforceable. I tell participants in my course that, no matter how brilliant your writing is, if it's not enforceable, it is a non-starter. And the enforceability is important, right?
So the anecdotal evidence is that it's not such a huge problem, at least from the ICC experience and the data. And but Darius, would you like to comment before that? In fact, the courts are aware of this, isn't it?
Indeed, right, Conrad, indeed, absolutely right. And the courts in some of the more popular places, Singapore courts, the Hong Kong courts, they've all said that they're not going to accept a due process challenge that easily, right? They'll defer to the tribunals running of the case. So absolutely right.
And of course, and finally, it's the arbitrator. If he's experienced, and because an arbitrator doesn't have a duty to ensure enforcement, even though a good arbitrator will want to ensure that his awards are enforced. But he doesn't have actually a duty in law. So a good arbitrator will be experienced enough to be able to handle it.
Well, I might just disagree a little bit with you, Conrad. When I teach people who are training to be arbitrators, I say your raison d'etre is actually to produce an award that's enforceable, because that's your product.
So I agree with you, because I said the outcome is to achieve that.
Yes.
Although in law, there's no such duty. You can sue an arbitrator because his award is not enforced.
My slight disagreement is this: when you say there's no duty, it's kind of
legal duty. I'm talking about legal duty as opposed to professional duty.
Where there's no legal duty, yes, I think where we have to be very clear about is, I think arbitrators have a professional duty.
Yes, a professional duty, yes.
To ensure that it's enforceable. So in that sense, I agree with you.
Okay.
And Conrad, what's the alternative? Do we go to court for international cross-border disputes? Every country has its own civil procedure rules. You'll be stuck in challenges. So I think parties have, at least in the more sophisticated contracts, and when I say sophisticated, I don't mean that there are some, the breadth has increased now of parties realizing that, look, no matter how good a court system in any country is, ultimately you're going to be subject to civil procedure laws, which is a very broad scope for interference, challenge. You're basically inviting a lot of delay. And therefore, if there is some due process paranoia here and there, I think still arbitration is far more effective in these international cross-border arrangements.
Right. So choice of your arbitrator, choice of your institutional.
Yes, exactly.
To guide the process.
Exactly. And the role of councils. And the role of councils can't be forgiven.
The role of councils, no doubt.
Yeah, exactly. I mean, that a lot depends on how the council...
Although sometimes councils actually are the culprits.
That's what I'm saying. That's what I'm trying to say. It's very important for councils to ensure that it functions and, you know...
choose the right council.
At least a process.
Absolutely.
Choose a good council.
Okay, Vivek, you said no alternative, but you know, Singapore, you know, we're always trying to invent new things. So we have, well, it's not a new invention by Singapore because there have been commercial courts in other parts of the world like London, Dubai.
Yes.
But more recently, in 2015, we've set up the Singapore International Commercial Courts.
Yes.
Perhaps now I'd like to go back to Darius. Darius, what do you... how do you weigh between arbitration and the Singapore International Commercial Court?
So as Conrad, you rightly pointed out, the SICC that was set up in 2015 was set up with the objective of combining the best of both worlds, right? So you've got a court process, the rigor of a court process, timelines that comes with a court process, but combining features of arbitration, right? But practically speaking, right, let's get down to the nitty-gritty of why clients choose SICC. I always tell clients we are just balancing two factors. The first would be cost versus enforceability, right? Comes down to cost versus enforceability. On cost, in an arbitration context, in institutional arbitration, the amount that you pay the arbitrators and the amount you pay the institution will increase as the value in dispute increases. Right? Whereas at SICC or before the Singapore courts, you pay a filing fee, you pay filing fees that is determined by the nature of the application, right? It doesn't increase just because you've got a $5 billion dispute. So that means for larger scale disputes, it's cheaper to use the courts compared to arbitration. So we've got that. But at the same time, if we go before the SICC, any judgment that comes out from the SICC is a Singapore court judgment. It does not have the benefit of the New York Convention. So in that sense, it's less portable. However, anecdotally, Singapore court judgments are relatively enforceable in common law jurisdictions like Malaysia, Hong Kong, India. So when we do the final cost-benefit analysis, if your counterparty is in a common law jurisdiction where enforcement is not such a big issue, SICC could well be the cheaper option that gives you the best of both worlds, the rigors of a court process plus the best parts of arbitration.
Right.
Yeah. I mean, I agree. And the only kind of caveat that I would have from, again, India cross-border perspective is that we would like to see more SICC judgments and the scope to challenge a Singapore or any other, India recognizes Singapore as a reciprocating territory for the judgments coming from its court. So that's not a problem, as Darius said. But the scope to interfere in that under a civil procedure is wider than the scope under the Arbitration Act. Right. Under the Arbitration Act, I can use 2 points very narrowly. It's against the public policy of India, and the Supreme Court has said public policy of India has to be something which is so germane to the Indian law. It can't just be that, you know, there's one law which, you know, it doesn't comply. But under the Civil Procedure Code, I have a wider gamut of challenge. So that could be one of the... So cost is important, obviously, for sure. But again, enforcement could also be, you know, should be looked at carefully. Right. And then you take a kind of a decision.
Right.
Yeah.
So right now, enforcement, it's the reciprocal enforcement of Commonwealth judgments. So if there are Commonwealth countries, then it's an option possible. But
yes, absolutely.
And there are limits to challenges. But there could still be challenges to the court order.
Yeah.
Otherwise, you have to sue on the award. But then that's where all the civil procedure and all the challenges come in.
Exactly.
There is also the convention on the choice of courts convention.
Yes.
Except that that's not been ratified by many countries.
Yes, not
China, Europe, US have all signed up to it, but not ratified it.
Yes. Yeah.
So when they do ratify it, then maybe this will get more traction.
Yeah. Could possibly.
I think that's a good point, Conrad. I was just going to say that I absolutely agree with what Darius says. I mean, it's a balance. But parties should watch the space because as time goes by, we think, just like arbitration, because of globalization of trade, it exploded in terms of breadth. I think that commercial courts like SICC will have an opportunity. Yes. As time goes by, parties will realize that, speaking of the convention that you mentioned, choice of law, eventually people will realize, look, this is a good system. Why don't we enter into this system, into this framework? And in fact, we know that in the early days, Singapore has, in fact, effectively tried bilateral arrangements as well. And I think that's another route. But a compendium, a convention or treaty would be good. But my point is, watch the space, because as things develop, I think everybody in business wants to see efficiencies. Yeah. And in this world, post-COVID, I think we need more efficiencies. So generally, I think the consensus view will be to find easier ways to do things, not difficult things. So my end point is watch this space. I think it's exciting. And Singapore will not be the only one, but overall, everybody in business will benefit.
So to sum up generally what we've discussed, so basically if neutrality and enforcement is not an issue, then SICC is a good competitive option.
Yes.
If neutrality and enforcement is not an issue, then it's a competitive. And before I leave this point, let me just touch on one more point, and maybe we can make the contrast between arbitration and SICC, and that is about multi-party disputes relating to the same subject matter or the series of transactions. Perhaps, Darius, you want to start off, the benefits and pros and cons between arbitration and SICC with multi-party projects. Construction is an example. You've got a main contractor, the subcontractor relating out the same project, but you have different contracts and different arbitration, or you may not even have an arbitral clause in one of the contracts. How do you handle this?
Yes, so Conrad, you've hit the nail on the head, right? Yeah. So one of the disadvantages of arbitration is that everybody needs to agree. Yeah. Right? And if you've got different contracts with different arbitration clauses pointing to different jurisdictions, you're going to have a real headache. And that's when the benefit of SICC comes in, because you can apply to the courts to join third parties.
Yeah. Right.
So absolutely hit the nail on the head, Conrad.
Yeah. Leslie, you want?
No, I agree with that. I mean, Singapore, even in the short time of last decade, we have many cases in Singapore courts dealing with this issue, and it is a headache. It's when you don't have the ability to join parties, it's always a difficulty. And of course, we're all very concerned with multiplicity of outcomes, which really brings the law into disrepute. That one court says this and the other court says that. Yeah. Right.
In fact, there has been a slight movement. For example, I think there's a decision from the Supreme Court of India on the group of companies doctrine in arbitration, where there was a party that was not a party to the arbitration agreement, but was so germane to the dispute that the arbitrator, the court interpreted that party can be effectively joined in the arbitration. Of course, this is developing jurisprudence. It goes against the grain of the fact that party autonomy and you decide who goes to arbitration. But there is, we'll have to see where that eventually ends up as well.
Right. So a court can compel a party.
The arbitrator also can compel in certain situations, and the court has said yes, under this particular doctrine maybe, but it's very early days.
Yeah. Okay. So, I've been told that we've got about 3 minutes before we go into Q&A. But let me just take a little bit of more time, because there's quite a lot of things that we still have to cover. And I'd be remiss if I don't talk about mediation.
Oh, yeah.
It's another mode of dispute resolution. What are the advantages or disadvantages of mediation? And when would it be appropriate to adopt mediation? And let's start with that question first. Professor Leslie, you want to?
Yeah, I think the key point for me about mediation, having sat as a mediator as well, is the fact that parties, with the advice of their counsel, must ensure that when they enter mediation, they are prepared to compromise. That's what mediation seeks to do. If they want an adjudication of their rights, a declaration of their legal rights, then the court is the correct forum. mediators do not have judicial powers. But if you are trying to find a process in which you amicably resolve your differences, then mediation is a good word. But the key word, I think, is compromise. Too often, parties think that it's some kind of magic. You come in and, you can solve it for me. But if you are not prepared to give and take, then it's a non-starter, because if you stick in your two corners, then obviously nothing happens,
So I'm going to rush you along. I'm so sorry.
Yeah.
Darius or Vivek, would you like to just add on?
Yeah, I mean, I've had a very positive experience in a mediation. I agree with everything the professor said. The parties have to be willing to compromise. I did one which was a AAA mediation in America, and it also all depended on how good the mediator was. I can tell you it was a senior level employment dispute, and both parties decided to go into AAA mediation. That wasn't in the contract, but they agreed to do it. And halfway in the process, it was as if, nothing was going to work out. But then in the next 2-3 hours, a compromise was achieved. So I think, obviously, the willingness to compromise, but also the ability of the mediator. The mediator actually plays the role of, I would say, a psychologist, as well as someone who understands the law to make that effective. So I'm very pro it. Even this whole mediation, ARB, MEDAB kind of principle that's now being talked about. But obviously, you have to keep in mind that you're willing to do it, you're open-minded, and that you're going in with the mental faculty that you are going to compromise.
Darius, would you like to?
Yes, just quickly. Obviously, mediation has the advantage of preserving the commercial relationship, so that helps to preserve the business moving forward. But in my experience, even if you don't settle it at the mediation itself, it helps to narrow the dispute between the parties. It helps to enhance communication between two parties who are otherwise fighting.
Yes.
And even if we don't achieve a settlement on the day of the mediation, it may well lead to a settlement as the days goes by, as the months goes by, when the cost starts mounting up for both parties.
Right.
Very true.
Right. So
agreed.
Mediation has the benefits of cost savings, speed. You can resolve a dispute quite quickly, flexibility in finding innovative solutions like let's do more business together, rather than fight over the past. Let's work together, so preserving relationships. So all the good things. But how do you enforce, if you achieve a mediated settlement agreement, how do you enforce it? Darius, you would like to?
Yeah, so we would typically advise our clients to nail down the settlement agreement right after the mediation. Do not wait a week, do not wait 2 weeks. We get it done, dusted, and signed. But obviously, the latest development would be the Singapore Convention on Mediation that's been signed, that will allow, that will function like the New York Convention, right? That will allow these mediated settlement agreements to be enforceable across different signatory states.
Right. Yeah. So the Singapore Mediation Convention is still in its early days as well, like the SICC, and is gaining traction.
Yes.
I believe some of the ASEAN countries have signed on to it, but they have not ratified.
Not ratified,
So,
including India has ratified.
and not in as well. So when they ratify it, then there'll be an easier process of enforcing your mediated settlement agreements. You don't have to sue on the settlement agreement and start all over again, right?
Yes.
Yeah. Okay. Where are we in terms of time? There's just a few more things I'd like to quickly touch on, and that is one of enforcement. And I'm just raising the topics, and let's see how much we can cover, but maybe in another round if we can't finish all this. One is enforcement and the pitfalls and challenges of enforcement. And I think we've touched on that even as we went along already. And now the more recent initiatives, at least from Singapore's perspective, is the litigation funding and conditional fee agreements to help push and help parties get the necessary finances. Any of you like to explain a little bit of litigation funding and the pros and cons of it? Maybe Darius?
Maybe Darius can,
Yeah, I'll be happy to, and I can do it very quickly. So the current position, at least in Singapore, is that third-party funding is permitted for proceedings before the SICC, international and domestic arbitration, as well as related court and mediation proceedings, right? So third-party funding is now permitted. The single biggest takeaway point that I want the audience to take away is that there is typically a minimum deal size before a funder will pick up a case, and the lead time for the funder to do its due diligence. So word of advice, if you want funding, start the process early, because you do not want to be negotiating terms of funding when you actually really need the funds urgently. You do not want your back to the wall, so start that process early.
Right. Okay, I've been just prompted to wrap it up already. So why don't I just go around, starting with Vivek, and maybe the key takeaways you'd like to make with regard to dispute resolution when you're doing cross-border transactions?
I think a couple of key takeaways. One is make sure that you have a well-drafted and simple dispute resolution clause, very clearly identified which institution. Try and avoid ad hoc if possible, and stick to some institution and its rules. And ensure that whatever you've chosen as your dispute resolution forum, whether it's a court, whether it's arbitration, whether it's mediation, that it's enforceable at the end of the day. I think these are the two very key takeaways from my perspective.
Leslie?
Yeah, I would just simply add on to what I think is a corollary point to what Vivek has mentioned, which is, I think the biggest takeaway for business people is take good advice before you launch into your multi-billion-dollar deal, because you know, when it unravels, it costs you a lot more than if you start thinking about things at the beginning.
Yeah, I was going to echo choose the right counsel is something that we've heard today. And the final thought from me is consider mediation. I think parties should seriously consider mediation.
Agreed.
And even as the fight carries on, there's no stopping parties from carry on talks in parallel with the fight.
Yeah, so maybe even multi-tiered dispute resolution processes to see different options to trying to find a solution. Well, thank you very much. You know, I hope you found the discussion insightful and hopefully helpful in your own forays into the region. It's now time for me to hand over to the organizers of this seminar.